Hi, thanks so much for joining us today for our webinar. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is oh, bleep, I blew my lien deadline. Now what? So without further ado, I'd like to introduce the fabulous and terrific Alex Barthet.
Thank you, Jesse. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today's topic is, oh shit, I blew my lien deadline. Now what? So let's go ahead and talk about how to solve that problem. So if you have any questions, go ahead and use the GoToWebinar chat box, which is on your screen. Submit your questions. We will answer them all at the end. Please do not include the names of any people or companies in your questions. All right, so what's the agenda for today? We're going to go over the basic notice and lien rules so everyone understands what they are. And then we're going to talk about the fact that maybe you only thought you missed a deadline because there's an exception in the lien law that means that you didn't have to send the notice that you think you needed to send. And I'll explain some of those exceptions. We'll talk about other bonds to go after. Maybe there are other bonds that exist that you don't know about that you can pursue your rights against. And then we'll talk about how to sue for breach of contract, how to sue for unjust enrichment, which are alternative legal theories to collect the money that's owed to you. And then we will, of course, answer any questions that you have. So let's get started. What are the basic fundamental notice to owner and lien rules? A notice to owner must be served within 45 days of your first work or delivery of materials to the site. To be clear, this is the date that the owner and contractor need to receive the notice. So if you put it in the mail on day 43 and it takes the postman 4 days to deliver it, well, it's going to be late. So it has to be received by the 45th day from your first date of work or first delivery of materials to the site. That's rule number one. Number two, your claim of lien, which is if you have lien rights, that's an encumbrance on the real property that you're improving, or the notice of non-payment, that's the document that you send if you have a claim against a payment bond. That's if the general contractor posted a bond on the job site, you would send a notice of non-payment, not a claim of lien. Either one of those documents need to be served within 90 days of your last work or delivery of materials to the job site. Remember, 90 days is not 3 months. Let that sink in for a minute. 90 days is not 3 months. Some months have more than 30 days. Some months have fewer than 30 days. So you need to make sure you check that you're counting all of the days. Real quick, the way you count the days is if today was the last day you did work on the job site or last day you delivered materials, tomorrow is day one. You're going to count every day, including weekends and legal holidays, all the way through day 90. And if day 90 happens to fall on a weekend or legal holiday, it rolls to the next business day. So if the 90th day was a Saturday, you go to Sunday. And if Monday the courts are closed, so you can't record a lien or deliver mail, it rolls to the following day. That's how you count the 90 days. The next major rule is that you have to file a lawsuit to enforce your lien no later than 1 year from the recording date of the claim of lien. So if you record the lien today, you have to file a civil action in court no later than 1 year from that date. If you have a claim on a payment bond, the general contractor's payment bond, you need to file suit, that is a lawsuit in court, no later than 1 year from your last work. Notice those rules are not the same. They have a different date that triggers the 1 year. If you do not file your lawsuit within 1 year of the recording date of the claim of lien or from your date of last work on a bond claim, you will forever be barred from bringing that claim. You will lose it. So you cannot miss that deadline. There are lots of exceptions to these rules, and there are a few other intermediary requirements, but these are the basics. This is what everyone needs to know to understand what your rights are. So the first question that we should look at is, did you really even miss a deadline? So you think you missed a deadline, but maybe you didn't. So let's talk about some of the most common exceptions we see where you don't need to send that notice. So number one, no notice to owner is needed when you have a direct contract with the owner. So if you are the plumber and the owner hired you to do work at their house or their commercial building, under the lien law, you are a contractor. And as a contractor, that is someone that has a direct contract with the owner, you do not need to serve a notice to owner. So you still have lien rights. No notice to owner, technically it's called a notice to contractor, is needed when you have a direct contract with the bonded contractor. Let me explain that again. If you're working on a private project and that project has a bond, meaning the general contractor posted a payment and performance bond for that project, and you have a contract with that bonded contractor, you do not need to send a notice to owner. Again, because you're making a claim on the bond, the technical term of that document is called a notice to contractor. You do not need to serve it, and you still have your rights against the payment bond. Now, in the first situation and in the second situation, you'll notice that I indicated you should still send it. You should have a process in your office that any job over a certain amount of money gets noticed, period. We see our most successful clients implement this rule. We see clients that sometimes make mistakes come to us because they try to remember all the rules, and they realized that, well, maybe I don't need to send a notice here, and I can save a few bucks if I don't send it here. And invariably something falls through the cracks, and a notice that should have gone out didn't go out. So it's better to do it the other way around. Notices are cheap insurance. You should send notices even if you don't need them. Exception number 3, no notice of non-payment is needed when you have a direct contract with the bonded contractor on a public project. So let me explain what that means. If you're working on a public project, think public hospital, public school, county courthouse, if you have a direct contract with that bonded contractor, so maybe you're the roofer on a public school project, you don't need to serve a notice to owner or a notice to contractor. That's that first notice that would normally go out within 45 days. I indicated that because you're in direct contract with a bonded contractor. But in addition, you also don't need to serve the notice of non-payment. That's the 90-day notice, because you are in direct contract with the bonded contractor. So that means if you have a direct contract with the bonded contractor on a public job, you don't need to send the first notice. You don't need to send the second notice. The only thing you have to do is file a lawsuit no later than 1 year from your last work. Another exception, on bonded projects, the 45 days for the notice to owner, again, technically it's a notice to contractor on bonded jobs, does not even begin to run until you have actual or constructive knowledge that the bond exists. So let me give you an example of a situation we helped a client with. Our client was a mason. They were a subcontractor on a public job. So there's the owner, the public owner, the bonded contractor, the subcontractor, shell contractor, and my client, the subcontractor, masonry subcontractor. So this job is public, so there was a bond, but the contractor inadvertently failed to record a copy of the bond, which is a requirement that contractor had. Contractors must record a copy of the bond to put the world on notice that that bond exists. They never did. So my client came to me about a year after he started the work and about 30 days after he had finished. The customer that he was in direct contract with, the subcontractor, filed for bankruptcy in federal court. So we had no claim against the subcontractor who hired us. And the client told me, he said, well, we screwed up in my office. We should have sent that notice, the 45-day notice to owner, and we never did. So I guess we're out of luck, Alex. And I said, well, let's do some research. And we did some research, and we realized that the contractor did not record that bond when he was supposed to. So there's a exception in the lien statute, which I'm telling you now, which is if the contractor doesn't record a copy of the bond, that is, you had no reason to know that that bond existed, you don't have to send that first notice. So we did our own research. We found a copy of the bond, and we served the notice to owner, technically the notice to contractor. Now remember, this is a year after he started his job, so it's clearly late under the basic rule, but with this exception, we served it. The next day we served our 90-day notice of non-payment. The next day we filed our lawsuit, and fast forward about 3 months of arguing with the other side and going in front of the judge a few times, we prevailed. And the contractor who made the mistake of not recording the bond had to pay us, and paid us our client's entire principal, interest, and legal fees. So that's a good example of a client that thought he lost all of his rights because they missed a notice, when in fact there was an exception in the lien law that gave him rights to pursue the claim, and we did, and he prevailed. So we talked about some examples of situations in which you think you may needed to have sent a notice and you didn't, right? There are others, by the way, those are the big ones, but there are still a few others. So don't just automatically give up. But there are other ways to recover the money that you're owed. And one of them is to see if there is another bond that you can go after. So the question you have to ask yourself is, if you were hired by the subcontractor, does that subcontractor have a payment bond? So if you are a subcontractor, a material supplier to the subcontractor, or a material supplier to the subcontractor, can you find a bond issued by the subcontractor? And if so, do you have rights against it? So one of the things you need to understand is that sometimes projects where you have lien rights, that is, there is no bond by the general contractor, that general contractor may determine on its own or in conjunction with the owner, you know what, we're going to get some of these subcontractors to give us a bond. So even though the contractor does not have a bond, the subcontractor does have a bond. Maybe they want that bond for protection to make sure that they pay their bills, like you. Maybe they are more interested in the performance bond component of the payment and performance bond. The performance bond component being to guarantee that the subcontractor is going to finish on time and finish the work consistent with the subcontract document. So there are situations in which the contractor doesn't have a bond, and the contractor doesn't have a bond, but the subcontractor does. So in those situations, if you can get your hands on that bond, if it exists, you may have rights against it. So the question is, how do you get your hands on this bond? Know that it is not recorded. This bond does not exist in the public record. This bond being the subcontractor's bond. So how do you get it? You can ask the subcontractor, who may or may not give it to you. They would like it if you don't make claims against their bond. Now, legally, if you send them a certified letter demanding a copy, they're supposed to give it to you, but they may not. The person that is almost certainly going to be very willing to give it to you is the contractor. Now, the contractor wants to give it to you because if they give you the subcontractor's bond, it can remove some heat against them, so you won't make a claim against them or the property because you're going to make a claim against the subcontractor's bond. So almost always, if you think that there may be a bond issued by the subcontractor, the contractor is the one that is going to be willing to give it to you. So once you get your hands on the subcontract bond, what do? you don't follow any of the rules we talked about, because those rules are the rules governing general contractor bonds. What do? You look at that bond, you find out what it says on how to make a claim, and you follow those rules. So the only way you know how to make a claim on a subcontractor bond is to physically have it in your possession and do whatever it says. Almost always it says, if you want to make a claim on this bond, you need to give us this information, and it gives you a little list. And that means you just have to mail it to them via certified mail, all of that information with a cover letter. And once you do that, you will have made your claim on the bond. And if they don't pay you, once you make that claim, then you can sue them to get paid. Now, I know we talked about a lot of rules. Those rules are very confusing. We have a free desk tool. You see the picture on the screen here. It's called the Lien-O-Matic. You can keep it on your desk, and it breaks down each of the rules by what role you have on the job. So once you determine what type of project, we cover private projects, bonded projects, FDOT projects, and Miller Act projects. Each of them is a separate page in the Lien-O-Matic. You just slide the little tab down to your role on that job, and then in the bottom there's an open window, and it'll tell you what you have to file and when you have to file it. So it's a great tool to have on your desk. You can get it at lienomatic.com, lien-o-matic.com. Fill out the information. We'll put one in the mail. You get it in about a week. All right, so we explained what the rules were. I explained some exceptions to those rules. We talked about a great way to get paid if the subcontractor has a bond and you've contracted with the sub. But let's talk about some other things you can do to get paid if you blew your deadlines. So you can sue for breach of contract with anyone that you have an agreement with. It doesn't have to be a written agreement. It's better if it's a written agreement, makes things a little easier, but a written agreement is not required. If all you have is a handful of text messages or emails exchanged, and that's your agreement, then that's fine. If you submitted a proposal, but it never got signed, but you still did all the work, well, you still have an agreement of sorts. The question is, what are the terms? That's going to make it argued, but you have a contract and you can sue for breach of contract. Maybe that contract's written, maybe it's oral, but you have legal rights. Now, where you run into the biggest problem and why it is so important to preserve your lien rights is if you sign a written contract that has a pay when paid provision in it. What does that mean? That means that the person that you've contracted with, right, the person that hired you, has a provision in their contract that says they don't have to pay you until they've been paid. Now, those provisions in Florida are valid and enforceable. We've done many other presentations on pay when paid. That's a whole nother presentation on what is and is not an enforceable pay when paid provision. Almost certainly, if someone is handing you a contract and it's been prepared by a lawyer, it's probably good for them and bad for you. And if you sign it, it probably has a pay when paid provision in it. If so, unfortunately, you may not have a claim for breach of contract if the reason that they're not paying you is that they haven't been paid. Little pro tip here, if you do work on public jobs and you think maybe the public owner has paid the contractor and the contractor's telling you, well, we haven't been paid, so we can't pay you, you can submit a Freedom of Information Act request to the municipality that's managing the job. And that Freedom of Information Act request, in that Freedom of Information Act request, you're gonna say, please send me a copy of the last pay request you received, a copy of your contract, all the payments you made, and they, as a public agency, are obligated to give you that information. And when they do, you will see whether or not your contractor has been paid or not. The other legal claim to make is to sue for unjust enrichment. So if you have not been paid, that is the unjust part, and you have conferred a benefit of labor and materials to the other party, that's the enrichment part, unjust enrichment, you have legal rights to be paid. Typically, we use this as a kind of catch-all, just-in-case claim. Our best cases are cases with lien or bond rights and breach of contract claims, but we always sue for unjust enrichment just in case as a fail-safe claim. Typically, we use this as a claim against a party that is further up the food chain. So, for example, maybe we represent a subcontractor who may have lien rights or may not. We may still sue the owner for unjust enrichment, claiming, well, we provided all of the plumbing or electrical work to the job and we haven't been paid. So you, owner, have all the benefit of our work and we haven't been paid. So you have been unjustly enriched and you should have to pay us. Unfortunately, if the owner has paid the contractor, but the contractor has not paid you, or even if you're further down, if the contractor has paid the sub, but the sub didn't pay you because you're a sub or a supplier, your claim for unjust enrichment will not stand because the owner isn't, there's nothing unjust about the situation if the owner properly paid the contractor. Yes, the money didn't get to you, but the owner isn't the reason that didn't happen. So if the owner has paid the contractor, your claim against the owner for unjust enrichment will not survive. All right, so let's recap. You need to know the basics of the lien law and bond claim rules. I showed you about the lien-o-matic so that you can get your copy and you won't ever have any questions about what rule applies when. We talked about exhausting all available exceptions to the lien law. There are many, so you just need to know that maybe there's an exception to the rule so that you can get paid even if you missed the deadline or you think you missed the deadline. If you're further down the chain, maybe a sub or a material supplier to a sub, maybe that subcontractor has a bond and you should make a claim against it. You can always sue for breach of contract, but watch out for that pay when paid provision, and you can sue for unjust enrichment. So with that, we are done. Jesse, do we have any questions?
Well, first of all, thanks so much, Alex. That was some really good information. I appreciate that. Yes, we do have a couple of questions that came through. So the first one, it says, do water or wastewater plants count as public projects?
Yes, absolutely.
Yep, exactly. Yes. All right, and then another question that came in, it says, is a bond required to be recorded on a private job?
Okay, so let me break down that question. Private jobs may have a bond. There is no requirement for a private job to be bonded. If there is a bond, because the owner or the lender of the project has required a bond on that private project, that bond is typically referenced in the notice of commencement, and a copy has to be a copy of the bond has to be attached to the notice of commencement when it's recorded. Now, there are many instances in which someone messes up the paperwork and there is a bond on a private project, but there's no reference to it in the notice of commencement and there's no recorded copy of it. That doesn't mean the bond is invalid. It just means that it hasn't been disclosed so that you would know. In that situation, you would record your lien because you don't know the bond exists, because to protect yourself, you only know that you have lien rights. And if somehow this bond turns up later, you will then subsequently make a claim by sending a notice of non-payment. I hope that answers the question.
Yeah, I think you went through it pretty well. If there's any follow-up question, please put it in the chat and then I'll make sure I address that as well. And then there's another one that says, you said that if the bond wasn't recorded, it extends the deadline potentially. Does that same rule apply if a notice of commencement isn't recorded until late?
Yes. Again, the law generally speaking, the law requires that, or the law says that an owner can only benefit from the requirements of the lien law if the owner follows the owner's obligations under the lien law. So it is the owner's obligation to ensure that a notice of commencement is prepared properly and recorded. And if the owner doesn't do that, the owner cannot benefit because someone didn't follow their part of the lien law because the notice of commencement wasn't either properly done or done at all. So the more common example that we see is that there's an incorrect address in the notice of commencement. The notice to owner is served on that incorrect address, which is what was written in the notice of commencement, and then the owner takes the position, well, I never received the notice to owner. The law says if you put that notice, if you put that address, that's the address I get to rely on in the notice of commencement. And if you did it wrong, that's on you, it's not on me. So as long as there is an obligation of the owner to do something, they cannot benefit by not doing it and therefore deprive you of your lien rights.
Okay, great. Thank you. And then another question, hopefully you'll have an answer for this one. It says, does the Freedom of Information Act request work for a public job that is in Panama?
Probably not, because I mean, well, let me back up. If it is an Air Force base owned and run by the US government, the answer is yes. You can submit a Freedom of Information Act request to the US government. If it is a Panamanian government property, or then no, the standard Freedom of Information Act request won't work. However, there may be some equivalent law in Panama, which I am unaware of.
Okay, thank you, Alex. I appreciate that. It says, on an owner direct purchase contract with a city county that has a GC with a payment bond, the GC has to approve all invoices and material with the city county before they approve payment. If GC is failing their job and not approving invoices and they are late over 90 days, can the supplier go after the GC's bond? What recourse does the supplier have?
Okay, this is an easy one. The answer is no. When you have a DPO, direct purchase order, with the owner, in this case a municipal contract, municipal owner, your contract is with the owner. So you are not in the chain of contracts that gives you any rights to make a claim against the contractor's payment bond. Your recourse is a breach of contract action against the party that hired you, in this case, the municipal owner. So at least as to the issue that was presented in the question, that the contractor is not doing their job, well, your contract is with the owner, so you should start complaining often and loudly to the owner that you're not getting paid, and that you're not going to deliver materials because you're not getting paid. And if that's because the contractor is not doing their job, I suspect that when you complain to the owner who you have a contract with, things will likely change.
Okay, great. I think that's all the questions that have come through. There was a little bit of a follow-up with Panama, but I'll reach out to them about that in particular case. But I do believe that's all the questions that have come through at this point. If anybody does think of a question that wasn't addressed, please feel free to reach out to us. We'll be sure to answer any questions for you as soon as possible. All right, so who is ready to win a gift? We are testing your knowledge again. I know this is information that Alex has gone over so many times. I know us at SunRay are constantly saying these things. So take a look at these questions. If you feel like you know the answers to them, please chime in the chat and we will send you guys out a free gift. All right, if you could go to the next slide, thank you. All right, so here are some SunRay resources to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's project information sheets, deadline calculators. There's, if you're working in a nearby state and you're not really sure what the lien laws are there. Remember, every state has their own lien laws, own set of documents and deadlines. So you can go to our state lien laws rules and select what type of project you're working on and what state, what your role is, and it will kind of tell you exactly what your deadlines are and documents are that you need to send. All right, so go ahead and perfect. All right, so we have a new service at SunRay. So SunRay Receivables will help you guys with your collection. So reach out to us if you guys are interested. Next slide, please. All right. Our next webinar with Alex is going to be August 15th. Your lien is worthless on a tenant build out work seriously. And then the next one is September 12th, chargebacks and bad checks, how to deal with them. So go ahead and sign up for free at sunraynotice.com/education. We'd love to be able to see you guys there. If you are in the Tampa area, Alex is going to be presenting alongside of Ariella for a live seminar on October 24th, how to get paid faster with liens, bonds, and contracts. It's typically a 2 to 3 hour presentation. It's really insightful, gives you lots of information. So go ahead and register. It's sunraynotice.com/seminars. All right, if you don't mind, take a minute to give us a review on Google. We really appreciate any feedback you can give to us and helps us get some better topics, information out to you guys of what you guys are wanting to learn about. So if you don't mind, give us that feedback. We'd appreciate it. All right, and the next slide. And with that, that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. Have a beautiful and wonderful sunny day. Thanks, everyone. Thanks again, Alex.